Welcome to Docnur. In today's video, we analyze a judgment delivered by the National Consumer Disputes Redressal Commission (NCDRC) dealing with allegations of medical negligence arising out of a forceps-assisted delivery. An appeal was filed in NCDRC by a practicing gynaecologist challenging the order passed by the Andhra Pradesh State Consumer Disputes Redressal Commission. The background of the case is that on 16th April 2011, the patient was admitted to a hospital in Nellore in advanced stage of pregnancy. On 17th April, she delivered a male child through forceps-assisted vaginal delivery. 2 days later, the child was admitted in another hospital where he underwent treatment till 4th June 2011. The patient alleged that due to the doctor's negligence, the newborn sustained crush injuries to the scalp, the right ear pinna was detached, and the child became mentally disabled as a result of brain damage. The patient contended that informed consent was not properly taken. The ultrasound findings had shown a baby weight of 3.6 kg warranting caesarean section. Despite the request, the doctor insisted on forceps delivery and the resultant injuries. This all constituted to a gross medical negligence as per the patient. Hence, a compensation of rupees 40 lakh was paid for under multiple heads, including treatment cost of rupees 4 lakh, mental agony and permanent disability. The doctors denied all charges, stating that the consent was voluntary, the delivery was uneventful, and Apgar score was normal. The child was examined by a specialist and discharged in healthy condition. The alleged injuries, that is subglial hematoma and necrotizing fasciitis, mentioned in the discharge summary of the second hospital, were secondary complications arising during treatment. After analyzing the evidence produced, the State Commission concluded that the medical negligence was established and awarded rupees 30 lakh for loss and mental agony, rupees 72,530 for treatment expenses justified by bills submitted, and rupees 25,000 as litigation cost. The doctors filed an appeal in the National Commission to set aside the order of the State Commission. Here, the patient submitted a disability certificate for the child dated 6th September 2017, allegedly showing that child suffered from 90% mental retardation with IQ of 25. This was countered by the doctor pointing out that the date of certificate was prior to the order of State Commission and it was never filed or brought on record and should not be accepted. The National Commission, upon hearing both parties and examining discharge summaries and consent documentation, found that the consent form did not mention any specific procedure. The exact words used were permission for doing operation for sickness. The consent was vague on a pre-printed form and cannot be called informed consent. Discharge summary mentions case of obstructive labor and outlet forceps delivery with right mediolateral episiotomy. But there is no record of any other finding on status of newborn. There were clear evidence of injuries to the scalp and ears as per the discharge summary of the second hospital. However, it was difficult to correlate the injuries suffered on the scalp with the subsequent mental retardation suffered by the child, as no evidence for and against has been produced by either party. Hence, the compensation was revised to rupees 10 lakh towards medical negligence and mental agony, rupees 72,530 towards treatment expenses, and rupees 50,000 as litigation cost. All amounts payable with 9% interest per annum from the date of complaint, that is 2011 till realization, failing which interest to be enhanced to 12% per annum. Legal takeaway from this case: lack of proper documentation is the greatest liability. In this case, inappropriate documentation of informed consent and discharge summary went against the doctor. Compensation is adjusted based on proof of negligence, injury, and its sequel, not assumptions. Although the compensation amount for mental retardation would have been higher, but the causality link could not be established with medical negligence. Subscribe to Docnur for more updates on landmark medico-legal cases and judgment analysis that shape healthcare jurisprudence in India.